Okay. Are you guys ready to begin? Okay. All right. Guys are ready? Thanks, everyone. My name is Savannah Everson, and I have the distinct honor of serving as editor-in-chief this year of the Albany Law Journal of Science and Technology. On behalf of the entire journal, I welcome and thank you so much for joining us here today. The Journal of Science and Technology originated in 1990, and it is a student-run journal consisting of 26 members this year. We publish articles on innovative and cutting-edge topics that cover the intersection of science, technology, and the law. Every year, our journal hosts a symposium on a relevant legal issue where we strive to contribute and advance legal discussion and scholarship. While our symposia are typically held in the spring semester, we're extremely excited to host it this fall in order to bring you information and discussion on a significant legal issue currently impacting the legal landscape. I want to thank our faculty advisor, Professor Robert Heverly, for his wisdom and guidance so far this year. Our journal is extremely fortunate to have Professor Heverly as our advisor, as he is an expert in numerous areas concerning law and technology. And finally, I am honored to introduce to you this year's symposium editor. She was appointed to her role as symposium editor this past spring semester, and she absolutely hit the ground running as far as planning and coordinating this event, and she has not let up for one day since. Her diligence and professionalism have been beyond impressive and appreciated, and it's been an absolute pleasure working alongside her. So without further ado, thank you all so much again for joining us today, and please join me in welcoming to the stage this year's symposium editor, Madeline Jones.
Thanks, Savannah. Hi, everyone. Thank you so much for coming today. It's my great pleasure to welcome you to today's symposium. I've had the privilege and I've had the distinct privilege to plan and coordinate. I chose this topic on April 24th, 2024, the day after the Federal Trade Commission publicly announced the ban that was then scheduled to go into effect on September 4th, 2024, which we now know, of course, it did not. The speakers today will focus on the history of non-compete agreements and how we got to where we are today in a position in which non-compete agreements could become obsolete in light of the FTC's proposed ban. Although the U.S. District Court for the Northern District of Texas issued a nationwide injunction blocking the ban from taking effect as scheduled, it's certainly not the last that we will hear about non-competes in the U.S., opposition to them, or institutions such as the FTC attempting their ban. Our speakers will discuss the hypothetical implications of a successful non-compete ban. We will explore the development in non-compete and NDA regulation and both federal and state trends in the area. Finally, the panels will focus on individual employees, specifically the disproportionate effect non-competes can have on minorities and other groups traditionally marginalized in the U.S., as well as the larger scale implications in industries as a whole. One of the most interesting aspects of planning this event today has been how dynamic the law has been in this area since I first chose this topic. Even the news of last week's election creates further uncertainty for the future of the Federal Trade Commission, making it questionable whether such a ban will ever pass into law. Today's panels should give you a better idea of why banning non-compete agreements may or may not be in Americans' best interest. I want to take a moment to thank everyone who made this event today possible. First, I want to thank Professor Heverly, who encouraged me from the start and made it possible for us to bring back a fall symposium for the Journal of Science and Technology. Next, I would be remiss not to thank our editor-in-chief, Savannah. She's been there for me every step of the way, whether I needed support, a solution, or just someone to rant to. I couldn't have gotten all this together without her, and our journal is so fortunate to have her leadership this year. Next, I want to thank all the members of the Journal of Science and Technology who've helped make this event a success. Thank you to all the faculty and staff in attendance and who have helped me to coordinate this event. I also want to extend a huge thank you to my family and friends who have listened to me talk about this event since last April. I'm so grateful for the support that this event has had from the start. And finally, thank you to all our amazing speakers who are here today and our moderator. We were so fortunate to comprise such an impressive and fascinating panel, and I'm really looking forward to hearing all of you speak. Thank you everyone for attending today to hear our wonderful panelists discuss this hot topic in the current legal climate in America. I encourage all of you to ask questions after the panels and to join us after for a reception in the East Foyer catered by Novo Kitchen. And with that, I would like to introduce our accomplished moderator, Albany Law alum Alyssa Rodriguez. Alyssa is Assistant General Counsel at New York Life Insurance Company. She is the co-head of the OGC Engagement Committee and OGC representative for NYL's Diversity Committee's core team. Alyssa attended Texas Tech University and graduated from Albany Law in 2018. Prior to joining New York Life, she worked as an associate attorney at Martin, Clearwater, and Bell, as a staff attorney at the Sanctuary for Families, and an associate attorney at Rawlin Henderson LLP. During her time in Albany Law School, Alyssa was the executive director of the Anthony V. Cardona Moot Court Program, an associate editor on Albany Law Review, the vice president of Student Bar Association, an executive board member of the Pro Bono Society, and she participated in both the Moot Court Constitutional Law Appellate and Civil Trial Advocacy teams. Alyssa received the Capital District Trial Lawyers Association Prize, was awarded to the National Order of the Barristers, and graduated with pro bono honors. Alyssa was also awarded the Albany Law School Excellence in Student Scholarship, the Albany Law School Platinum Public Service Award, and placed third in the Bruce M. Stargett Legal Ethics Rating Competition. So I think I speak for all of us when I say we're very lucky to have her back with us today to moderate our panel. Thank you, Alyssa, and welcome.
Hi, everybody. Madeline made me sound way cooler than I was, so thank you very much. It is such an honor to be back. I'm happy to be moderating and look forward to this discussion amongst our panelists. So as Madeline had said, this symposium investigates how non-compete agreements came into law and how they impact the labor and employment field and touch so many other areas of law, the workforce, innovation, and competition, with a specific focus on the role they play in the big tech industry. Today's symposium will consist of two panels with a brief intermission in between. The first panel will set a foundation for non-compete law, and the second will focus on the implications surrounding the proposed ban and the future of non-compete law. So this first panel will feature Professor Michael Hutter of Albany Law School and Professor Orly Lobel of University of San Diego School of Law, who is joining us virtually. Professor Hutter's teaching focuses on litigation courses, including evidence, New York practice, federal jurisdiction and trade regulation, antitrust and business torts, conflict of laws, and trade regulation. He joined the Albany Law School faculty in 1976. Professor Hutter is a recognized expert in covenants not to compete and trade secret matters, a past chair of the ABA Litigation Section Business Torts Litigation Committee, and the inaugural editor-in-chief of the ABA's Model Jury Charges in Business Torts Cases in New York Evidence. He is a frequent lecturer on trade regulation topics and has authored several articles on those topics. Professor Hutter is an elected member of the American Law Institute and a fellow of the American Bar Association and New York State Bar Association. He is also a past president of the Albany County Bar Association. Professor Hutter graduated from Brown University and Boston College Law School, where he served as the editor-in-chief of Boston College Law Review Annual Survey and was elected to the Order of the Coif. After graduation, Professor Hutter served as law clerk to Judge Matthew J. Jason, an associate judge of the New York Court of Appeals. He currently consults on trade regulation matters with law firms and corporations. Also joining Professor Hutter is our second speaker, Professor Orly Lobel of San Diego University School of Law. She will be also delivering the keynote speech at the end of today's program. Professor Lobel is an award-winning author of numerous best-selling books and articles, a Warren Distinguished Professor of Law, and founding director of the Center for Employment and Labor Policy at University of San Diego. Professor Lobel's area of legal expertise include intellectual property, employment and labor law, tech policy, artificial intelligence and the law, innovation and human capital, and equality and discrimination. Professor Lobel has received numerous research grants from the Robert Wood Johnson Foundation, the American Bar Association Litigation Fund, the Cyril Kaufman Fellowship, the Southern California Innovation Project, and NetSpar. She is a member of the American Law Institute and serves on the advisory board of the San Diego Lawyer Chapter of the American Constitution Society, the Employee Rights Center, and the Oxford Handbook on Governance. Her articles have won several awards, including the Torsness Prize for Outstanding Legal Scholarship and the Irving Oberman Memorial Award. She was University of San Diego's Herzog Endowed Scholar for the 2012-2013 academic year. And she was also the 2013-2014 recipient of USD's Thorsness Prize for Outstanding Legal Scholarship. She also serves on the advisory board for the Future of Privacy Forum. Professor Lobel graduated from Tel Aviv University and Harvard Law School, clerked on the Israeli Supreme Court, and is a member of the American Law Institute. Professor Lobel has published extensive scholarly works, including several publications on non-compete agreements and their potential ban. So with all that, I first welcome Professor Hutter to kick off today's program.
Thank you. Good afternoon. My talk is just really going to be a setup for what you'll be hearing on both the rest of the panel, Professor Orly, and the second panel about covenants not to compete, how they got started, where we're at now, and the issues that are going to be confronted. But let me start with what I wrote some 50 years ago here in the Albany Law Review. Every firm whose profits depend upon the use of confidential business information run the risk of incurring serious losses if such information were to be acquired and used without authorization by a competitor through the efforts of a departing employee. That's the keystone. And that started the trend in the beginning of covenants not to compete, restricting the ability of a competitor, of an employee, when leaving a present employer, from joining a competitor or setting up a competing shop. It's interesting that historically, the first cases that appeared dealing with covenants not to compete were at the end of the 1500s, early 1600s. And English common law, they were denounced, and I mean denounced, as harmful, detrimental to the growing economy of Great Britain. And they were just unlawful. Well, about 100 years later, when we start getting into the beginning of the Industrial Revolution, complete change of heart. In the leading case, it's still cited, Mitchell versus Reynolds. In 1711, the English common law said, you know what, maybe they really are necessary. And maybe we should now invalidate them, but we should scrutinize them. See if they are reasonably necessary for the protection of confidential information, maybe certain employee skills, but let's not go into an outright ban. Now, since 1711, in the United States pretty much followed the reasonableness standard of Mitchell. And it did so with a kind of a two-pronged approach. Are these covenants necessary to protect a legitimate business interest of an employer? And secondly, if they are they reasonable in the sense of geographic limitations, time limitations, competitive activity limitations? But it's basically reasonable. Now, since then, almost all courts follow, the majority of courts, I'll say, follow in large part the common law of Mitchell v. Reynolds. And in doing that, we've also seen at this point 4 states that have outright condemned covenants not to compete: California, North Dakota, Minnesota, Indiana. Now, simply no, not at all. The remaining states have a melange of various things dealing with covenants at the present time. And it's interesting that everything really started with respect to the enforcement of covenants not to compete, the modern era here in New York. And it started with a TV personality who's in the audience, Sue Nigra, who was a enterprising reporter for Channel 10. And she was tremendous following, really he got to the heart of things. And not surprising, when her contract ended with Channel 10, she had some pretty good offers that doubled her salary. But Channel 10 said, no, we're not going to let you go. Here's the contract. If you don't sign it, you have a covenant not to compete. Well, Sue sued, and she prevailed. And it started the trend in New York to take a stricter look at what's going on with covenants not to compete. And then it led to New York abolishing covenants not to compete in the broadcast industry, and which then led to a national revolution in that area. But that started the ban rolling. And what was happening is realization of the abuse of covenants not to compete, which really were epitomized by Jimmy John when they tried to pose covenants not to compete on the subway, the sub builders, the kids who now would slop a couple of slices of cheese, a couple of slices of ham. Somehow there was a trade secret involved. It was ridiculous. And that overreaching started realizing now it went a lot further. And to the credit of President Obama, to the credit of President Biden, this is before the FTC. They started inquiries into, are these covenants not to compete really worthwhile? Are they helpful? Are they keeping progress down? Technology. We need some more study on this. And there were a lot of public hearings involved. Sue's law firm, her partner, Mr. Beck, provided a lot of testimony regarding the need for these, but again, a judicious use. Now that started then the FTC. Once we had now President Biden in, a new FTC chief, Professor Khan from Columbia Law School, he then started the ban rolling for covenants not to compete, and that proposal of April '74. But that's not the only thing. We then had the National Labor Relations Board jumping in. Maybe it's an unfair labor tactic now to subject employees to these ridiculous covenants not to compete, the overreaching. We had a lot of states now jumping in, including New York, which the legislature surprisingly passed a bill to invalidate all covenants not to compete, which Governor Hochul vetoed last December, but suggested that if you bring to me a more reasonable bill, I'll take a look at it. There are also numerous states that have legislative hoppers full of these bills. The Beck Biden Reed law firm keeps a running tab of all the legislation going out there. I think a lot of them are on hold to see what the FTC was going to do, but I think we're going to start seeing a lot more activity on the state level, and with the FTC proposal is struck down. Then we even have the Uniform Commission on State Laws. They have a proposal dealing with covenants not to compete, which is kind of unusual because they had stayed away from that for many, many years, but they're jumping in. The point now is that recent events have shown that covenants not to compete are in an uncertain area. The question here is, yeah, we probably need them. I'll say probably, but how far should they extend? How far should they restrict? What do we do about these restrictive covenants that now deal worldwide, especially in the era of the internet? It's more and more thinking as to how to handle them. And I think a lot of it now is going to start with not necessarily to abolish them completely, but really it comes down to lawyers and businesses to start looking at them with a more critical eye instead of the blunderbuss approach. Oh, we need them. Why? Because we need them. Let's look at, do we really need them? Is there really a trade secret out there that needs to be protected? Is there a legitimate interest? Let's look at that industry-wide, whether it's broadcasting, physicians, and no attorneys. Their attorneys are barred by reason of the Code of Professional Responsibility. But there now is a more and more nuanced view of covenants not to compete, which was not there a long time ago. And I think what you'll hear from this conference is how they can be worked, they can be kept, but it's the lawyers that have to do the policing. The careful work with their employers, with their clients, to make sure to avoid the overreaching. which was almost with that death knell with Jimmy John, really was almost to put the kibosh on covenant not to compete completely. But the point is now we're in exciting time. And even a New York Court of Appeal, in a recent decision about 5 years ago, in enforcing, still kept to the Mitchell v. Reynolds, was very clear. Justice Judge Stein was very clear in her decision as to we have to scrutinize these covenants to compete very carefully. No rubber stamping. We want to see justification. We're going to adhere to them. We want the justification. Barring no justification, we'll strike them down. And that, I think, has set the tone for the cases in New York and because of the influence of the New York Court of Appeals for other states. But these are, without a doubt, exciting but uncertain times for covenants not to compete.
Thank you, Professor Hutter. And to continue that conversation, we will now hear from Professor Lobel on Zoom.
Hi.
Oh, just 1 second. Let me close this real quick. How do I make this big or move this over? Boom. All right. There you go, Professor Lobel.
Hi, can you hear me fine?
Yes.
Okay, I actually have some slides I'm going to try to share. Let's see. Can you see my slides?
Yes.
Great. Okay, so thank you. Thank you, everybody, for hosting all of us and for inviting me to keynote this really important and timely event. And I really commend the law journal editors who've been so thoughtful in putting all of it together and talking to me before the event and planning. This is a ongoing struggle and research agenda and really issue that is so important to millions upon millions of American workers around the world. But also, and this is very much part of the point that I will be making throughout my keynote, and as the editors of the journal have emphasized, it's also a really important issue for industry, for businesses, for innovation and competition policy at large. And so I want to, just for now, before the keynote, set out some of the basics on what we're talking about, what is a non-compete, but underscore that we—
Professor Lobel,
Yes.
so sorry to interrupt. Right now, we are seeing an email. I'm not sure if that's a
not
different
what you
screen.
needed. Nope. So I'll stop share and start again. I think I'm in 2 screens, so I'm just
Oh, not a problem.
start jumping around. Although you saw probably an email that was
I
very
was hoping it was winning lottery numbers and it was not, so.
No, it was, I think, just updates, just fresh from today about the, let's see. Let's start this again. What do you see now?
I still just see you. It doesn't look like you're sharing a screen any
Okay.
longer.
So I'm stop sharing. Did you see the PowerPoint at all at some point?
Yes, yes.
Okay.
And then it changed to the Outlook screen.
Right. I don't know how that happened, but let's see. Share. Okay, what do you see now?
Still just, it doesn't look like you're sharing your screen.
Okay, but I am sharing it because it says stop sharing. Okay, well, we'll figure it out by maybe the next talk, because I have some nice screens for you. But let me, for now, I don't need the PowerPoint, but what I want to say is that a non-compete is an employment contract clause, but it can take many forms. And that's one of the exciting things that is happening with the FTC rule and the national conversation, that we're starting to understand that covenants not to compete can take several forms. They don't have to be the straightforward post-employment prohibition on establishing a new company or not working in one's industry for a period of time and a certain geography. So I want to say that the FTC Act does something that is quite broad, from my view, in a very positive way, on 3 different levels. First, it says that a non-compete is an unfair method of competition under the FTC Act, under Section 5 of the FTC Act, which the Supreme Court has explained Congress enacted Section 5 to combat practices that stifle competition. And indeed, I will talk to you about so much evidence, so much empirical evidence. We've reached a critical mass of research that shows that non-competes detrimentally stifle industry competition and innovation. The way that it's drafted, the FTC rule calls a non-compete clause a term and condition of employment that prohibits, that's the straightforward non-compete, prohibits a worker from, or penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the United States with a different person, or operating a business that's competing after the conclusion of its their former employer employment contract. So what I just said, and I have a nice slide about this, about penalizes, functions to prevent, not only prohibits, that has been an expansion of the way that we understand non-competes. And it includes also clauses that are, for example, NDAs that are so overly broad that define every knowledge, every skill, every piece of experience that one has learned throughout their career or their job with a former employer as off limits, as covered by this NDA. And the FTC rule gives as an example that as being also a non-compete clause, which is prohibited now under the FTC new rule. That's one way that it's a broad rule. The other way that it's a broad rule is that it makes it unlawful for an employer to present, enforce, or otherwise use a non-compete to try to create some signal to the worker that they are not allowed to leave. And so that's very important, because what we know from the research is that most non-competes will not be litigated in court, that there will be a huge chilling effect on just the decision of an employee to leave their employer, to try to seek new employment, to try to leverage an external offer to improve their conditions, their terms, their pay at their current employer, when they see a non-compete clause in their contract. And the research has been showing, and this is the FTC really doing a lot of work. So if you read the 2024 rule, FTC rule, the report itself is, I think, 360 pages long, with a lot of evidence-based thinking and research and analysis on the breadth, the spread, and the effects of non-competes. And what really has been happening is that a vast majority of employees in every industry and every type of profession have been running into this request, this presentation by the employer of a non-compete, and that in itself has an effect, not just when an employer actually litigates or tries to use it post-employment to prevent that employee mobility. So that's the second way that it's a broad rule. So both the way it defines non-competes and also the way it defines the illegality of using these clauses, not just in litigation, not just in enforcement, but even presenting or signaling that this is something that is lawful. And the third way that the FTC rule is broad is that, as you know, we've been having a lot of litigation and fights over who is an employee in other areas of employment regulation. So, you know, all the Uber fights on whether Uber drivers are employees or are they independent contractors for the purposes of wage and hour laws, for the purposes of our civil rights laws, different safety protections. And what the FTC rule says is that basically the rule is agnostic. It defines workers as any natural person who works or who has previously worked, whether paid or unpaid, without regard to the worker's title or the worker's status under any other state or federal law, including but not limited to whether the worker is an employee, independent contractor, extern, intern, volunteer, apprentice, or a sole proprietor who provides a service to a person. So the coverage is really broad. There, even if you're a freelancer and you're asked to sign a non-compete post using your services, that too is invalid. Now, just about the history of the proposed rule was, it was proposed in 2023. The FTC received over 26,000 public comments. 2 of them were mine. And the vast majority of the comments were in support of this national ban. So in 2024, the final rule was adopted after that long notice and comment period. And now we're at the moment of challenges, as was described already in the introduction. So I'll just say where we are on the court challenges. The 11th Circuit will be hearing the appeals of the case. It's called Villages versus the FTC, which was originally filed in Florida. And the FTC is appealing a grant of a preliminary injunction against the rule. And that will be in, I think in a few weeks, there will be the opening brief of the FTC. That's what's expected. And then in a few more days after that, these really in the next few weeks again, the other case is the Texas case, the Riden versus FTC, that was originally filed in the Northern District of Texas, where Judge Brown ruled against the FTC on statutory and administrative law grounds, saying that the FTC does not have the authority to write competition rules and did not have sufficient evidence to ban non-compete clauses for all workers. So I actually will present to you the evidence, some of the very robust evidence about the ban on non-competes. But just to say, these are 2 different grounds. So the Texas court was focused on just the general authority of the FTC to regulate competition. And the 11th Circuit is focusing on the major questions doctrine. And then the third case was dropped just last week in Pennsylvania, where there was a denial of the preliminary injunction in Pennsylvania. And just really fresh off the press from today, just a couple of hours ago, 17 attorney generals, including our California Attorney General Rob Bonta, filed an amicus in defense of the Federal Trade Commission's prohibition of non-competes. And it's a multi-state coalition that really is very much in support of the rule. I'll talk more about California and the fact that unlike what we just heard from Professor Hutter, who's correct that in most states we've had non-competes and their enforcement within the standard of reasonableness. Here in California, since the inception of the state, we've had Rule 16600 that completely bans non-competes, just like the FTC does. So this conference is all about tech, the tech industry in particular. And we in California, as everybody knows, we have Silicon Valley up north, and here down in Southern California, we have Biotech Beach, we call it. We have a very active pharma, biotech, high-tech, entertainment industry, and we've all seen them grow as the premier places in the country for these competitive, innovative regions without the enforcement of non-competes, because from the inception of the state, we in California do not enforce non-competes, and the FTC rule has been meant to expand this California prohibition to the rest of the country. So I think I'll stop here, and I look forward to a lot of discussions.
Thank you, Professor Lobel. Are there any questions from the audience so far on what you've heard in these panels, and also anyone on Zoom? Feel free to, let me see if I can pull this out actually. Oh, we have a question in the back. Oh, we're gonna bring a mic.
Can you hear me? Anyhow, so what rises the NDA to the level of a non-compete? Like, what's either the floor or, like, what's the minimum amount that's included in the NDA before it becomes an actual non-compete agreement?
Yeah, I'm assuming this is for me, the question.
Yeah.
Yeah, so what the FTC says is that it basically, and this, it actually says this in relation to the broader rule in general, that a lot of this is really to codify state laws. So it refrains from drawing those lines of what is a valid NDA and what is an NDA that is a non-compete. It just uses that functions to prevent terminology that will be subject to interpretation by the courts. But it does give an example of a non-compete that is so broad that it just says all information related to your industry or to the type of profession or research that you're doing in this industry, in that you did with your previous employer, is confidential and proprietary. And effectively, that means that somebody cannot use their knowledge. So I think what it does is just remind us of what has always been correct. And I think that's a huge issue that will be the subject, not only on the frontier of what are unenforceable, invalid NDAs because they are functioning as non-competes, but also should bring more of the action. This is actually a subject of a new article that I'm writing. Will bring more action and more, I think, respect and kind of right or more correct ways of litigating trade secrets or trade secrecy generally, to remind us that trade secrets are only secret when they are, or only protected when they are indeed trade secrets. That means that they are secret, that they derive economic value, independent economic value from being secret, and that the company is exercising reasonable measures to maintain them secret. And from my perspective, I would say that any NDA that purports to cover as confidential and proprietary post-employment information that is not a trade secret, that is readily ascertainable from with out of public means, that's out there in the public domain, that is readily known, is reverse engineerable in the industry, that is an invalid non-compete, because it puts former employees on a different playing field than anybody else who wants a new job in an industry and can use those skills that are flowing and out there in the market.
Any other questions from the audience or on Zoom? Professor Bell, I actually have a question. How would this proposed ban, assuming it goes into effect, or if it would have gone into effect, how does that affect garden leave? Or does it not at all? Because that's technically not post-employment, you're still employed. It's just, you don't have access to the business.
Yeah, I would argue that it does affect garden leave. So garden leave, for those who don't know, it has been kind of a compromise between saying non-competes are non-enforceable when they completely mandate somebody taking a forced sabbatical outside of their profession, not competing in the industry. But a garden leave is kind of that compromise of saying, well, those are not enforceable, but if somebody's paid during that time, then that compensation makes the non-compete valid. And that's something that has been the compromise in some European countries. Massachusetts has something similar, and some state laws or state courts have considered that in relation to the reasonableness, and when they're just generally looking at whether this non-compete is reasonable. I would argue, because I'm going to argue in my keynote, that non-competes have a harmful effect not only on the employee that's sitting it out, but on the market at large, on the innovation potential and competition of startups, new entry into the market, by being able to recruit people who are skilled in the profession. That harm is not something that you can overcome simply by putting somebody on a garden leave, or simply by showing that you're paying somebody to respect a non-compete. So I think that the FTC rule is clear on this, and I think from kind of all of we know from the jurisprudence in California as well, that garden leaves will not be a way to get around the prohibition on non-competes.
Thank you. And if there's no other questions from the audience, we are actually going to take a break until 4 o'clock, and we will start the second panel. Thank you very much. Shouldn't stop share, huh?
It was.
But then I thought, should we just message her? Sorry.
No. I was actually going to say, is it easier to have her email it to you, and then I could have.
I don't know, because then she can't control it.
And then she's not.
I saw it, yeah.
I thought that too, but we could see her screen for a minute. First of all, we're gonna do this. Yeah, so that's what I was getting texts. You probably think I was just texting the whole time. It was all about this. People could still see her email. She was sharing, the email was up. So I'm wondering, I mean, we want to share this to start. She's not gonna talk again until the very end.
The audience is garden leave.
Should I call her?
Do they really?
Is that crazy?
Yeah, one of my things would be,
We made a mistake too. We should have had someone
look at
up on
garden
that
leave.
dude, like.
Hey, get out of here. But also, I've been seeing a lot. The company will keep the high level executive on a consulting basis. That I think is legitimate. If they have actually do some work.
Do you mind? I'm sorry.
Semi.
Yeah, sure. Yeah.
Hi, this is Orly. I was wondering if you see my PowerPoint? They're like on a break, so.
You have a couple of chats, so maybe.
Oh. Let's see.
Okay,
I can see.
they can see.
Okay, I'll just keep it right now on. Okay.
You want me to close the door?
No, I'm going out from
Can everybody hear me? Yes, great. Thank you for having me. I haven't been, true disclosure, I've not been back in this particular room since my moot court oral argument many, many, many years ago. So it is nice to be back. And thank you so much for having me. So my practice in labor and employment is kind of twofold. I do a lot of employer assistance, as was said during my bio, in looking at the policies, looking at agreements, trying to assist in ensuring enforceability. But what my role on the panel today is to really focus on the employee perspective. And the other part to my practice, to my employer management heavy practice, is I assist employees in really navigating either upon hire or upon separation of employment in kind of reviewing whatever employment contracts they have and any type of non-compete, non-solicitation, NDA type of agreements. And as was said during my bio, I practiced for a decade as a criminal prosecutor and made this kind of crazy move into private practice about 6.5 years ago. And in my time in private practice, about that time, 6 years, I have seen this come up in so many different ways, shapes, and forms. And so I want to first start with what it would look like from an employee perspective if this FTC ban went into effect. And from at least my perspective, it would kind of, I don't want to say do away with the issue of non-competes, but virtually. And the reason is really to what Professor Lobel's points earlier, the three kind of tenets that she spoke to as to why this particular ban is so broad. And that's why, from my perspective, from the employee perspective, if this ban went into effect, it would really kind of do away with them because it is so broad. It touches on not even just employees, interns, vendors, independent contractors. It also encompasses so much more than competition. To the question earlier about, when does an NDA rise to the level of non-compete? It's exactly that. The way that the ban is written or the rule is written, it could really apply to non-compete, non-solicitation. Non-solicitation is where you prohibit former employees from contacting clients or customers of a particular, your former employer. So I think from an employee perspective, if this ban goes through, it's going to be really beneficial for employees. They're not going to have to worry about navigating the non-compete agreement when they get it upon hire, or when they're asked, to become manager, or when they're asked to potentially accept severance upon separation of employment. So I don't really want to spend a ton of time on what it would look like if the ban went into effect, because I do think, quite frankly, it would be really life-changing for a lot of employees. And I'm sure Professor Lobel will speak to all of the reasons why the ban would be beneficial in assisting employees in that area. And I think Sarah might touch on this too. Another reason why, why I believe maybe the ban won't happen is because of, our incoming president and the fact that the ban, was proposed and implemented or attempted to be implemented under the Biden administration. We don't know what it's going to look like when President-elect Trump comes into office. So I kind of want to just focus on what would happen if the ban doesn't go into effect, because quite frankly, that's the world we're living in now, and that's the world we've been living in for years and years and years, as Professor Hutter said. So one thing I want to highlight, which Professor Hutter referenced, is there is no law or regulation in New York that generally covers non-compete. So we have to look to case law, common law, what type of standards have been developed and things of that nature. So that really is what guides our analysis. What I will say, which also Professor Hutter touched on, was that the legislator in 2023 passed in both houses a non-compete ban. The governor vetoed it in December of 2023. But I think that we're going to see that kind of come back again. And I think the reason is because keep in mind when the legislator or when the governor vetoed it, this ban, the FTC ban, was proposed, right? So there was that understanding or appreciation for the fact that the federal government was going to potentially be regulating this. Now that is, that is in question. And so, I think that we're going to kind of see it again. And then also the governor's veto message pretty clearly said that she would consider another type of bill on this if it had some type of guardrails, like salary thresholds, maybe focusing on lower or middle income employees, that she specifically made reference to those in her veto message. So I don't think that this is the end of it in New York. I think we're going to see more of it in this next legislative session. So with that in mind, what are kind of the things that are happening in the non-compete world that I think kind of shed light on why some type of regulation is necessary, okay? Why this has become so problematic. And I will tell you, the first thing that comes to mind is that the folks who are most impacted by non-competes are lower wage workers. So typically, non-competes can kind of come in many forms. They can be, I think Professor Lobel said this, it can be a clause in an employment contract. It can be part of an NDA. It can be part of, I don't know, some other onboarding paperwork that you can get when you're hired from by your employer. But let's say you are just, your employee making median wage salary, and you're given this employment contract or, book of sets of policies upon hire, and one of them is a non-compete. And you're like, well, who cares? It doesn't matter. I'm never going to worry about this. I need this job. And you just sign it. Those are the individuals that are the most affected by the non-competes, because then what happens is potentially that they get laid off or they decide to go in a different direction, and they're now trying to navigate a non-compete. And oftentimes when folks call me when they're looking to either leave employment and need some help getting there, or they're trying to negotiate their severance or their separation, the first question I ask is, well, do you have an employment agreement? Maybe, I don't know, I'll have to look. And then it's, well, do you have any non-competes or restrictive covenants? Well, I don't know, I'll have to look. And the fact that that's not something that they know or that that's top of mind is the reason why some type of regulation, whether it be this FTC ban or something in New York, would really benefit those folks, because they don't know what they're signing 90% of the time. I won't say 99, but 90% of the time they don't know what they're signing. And I'm now at the back end having to help them navigate a clause or an agreement that, one, could be very detrimental to them because it is so restrictive, or two, is so poorly drafted that I can't even tell them what it means because I don't know what the terms are. And so I would say that from my practical standpoint is the biggest concern that I would say over trying to regulate in some way, shape, or form non-compete agreements. So as I mentioned, the timing of the non-compete, or when you're presented with the non-compete, is kind of critical, right? It can be at the time of hire. And again, if you're just, the average worker who's just excited to be working for maybe this new company, you're just going to sign it. It can also come maybe if you're getting promoted, or if you're looking to kind of move departments and they say, well, you're going to now be elevated in the company, you need to sign this. Another time too is upon separation from employment, severance agreements, you're getting post-employment benefits. We're going to give you those post-employment benefits, but you're going to have to give up some of your rights to compete, kind of along the lines of, not exactly like garden leave, what we were talking about earlier, but similar kind of concept. So particularly with folks who get presented with non-competes or restrictive covenants generally upon hire, the one thing that I would say is that while it might be kind of daunting to try and dive in and kind of parse out the agreement, it's really important to do it at the beginning of your employment for a lot of reasons. One, so that you know what you're getting into, right? You might not, your non-compete maybe for a month in this, 12 months in this specific area. And that's just not feasible for you, meaning you can't not work for 12 months in this area because you need to support your family or something to that effect. So really doing that deep dive and reviewing the agreement is kind of critical for that reason, to know what you're getting into. But second, it also allows you to be able to ask questions. Now, folks who are in like the median salary range, right? And when I say median, I'm thinking somewhere to like from like, you know, $40,000 to like $75,000, right? Like the median range of where folks are likely not maybe in management positions, but it's a good job, it's a steady job, it's something that's going to give them some security, and it's important to them. So, you know, at that point in time, you're able to ask questions. Now, will you be able to negotiate? I don't know, right? Because if you're just coming in and this job means a lot to you, you might not want to get involved in some type of negotiation, but you can certainly ask questions. And that's something, again, that if you're doing it retroactively, like when you're leaving, and maybe you got fired for, you know, for cause, maybe you messed up and you did something wrong, and now you're trying to understand like, what does my next move look like? You then know and are able to say, oh, I remember when I got hired, I asked them what competing business meant, right? So then you know, oh, competing business means, you know, to offer Professor Hutter's example before, making sandwiches, right? I'm being a little loose, but that's, you know, you'll know what type of competing business it is in order for you to understand, okay, does this make sense for me to enter into, or maybe I need to find another job. So just from my perspective, I think, and I do see it, is that folks often are just kind of really unaware of the parameters of their particular non-compete or non-solicitation. So, you know, in New York currently, and it's been our standard for a very long time, it's reasonableness. And Professor Hutter referred to this earlier. So it's, you know, whether or not it protects the legitimate business interests, it needs to be narrowly tailored, not overly broad to burden the employee, and it can't be against public interest. So what that essentially means is that in every type of situation where you're trying to litigate a non-compete, it's going to be very fact specific. I mean, my favorite phrase to tell clients, I'm sure Sarah would agree, is, well, it depends, right? You know, can you give me an answer? Oh, it depends. Because every case is different. But I just want to kind of highlight a few things that I have noticed in my practice when it comes to non-competes that kind of either raise red flags or are things to kind of look out for. So one is a defined term, and I mentioned this earlier. So what does a competing business mean, right? Does it mean what you think it means, or does it mean something different? Who are your clients or customers that you cannot engage with? Are they clients or customers that you've worked with? Are they clients and customers of the company in general? I can't tell you how many times I've seen agreements that cover current, past, future, or, you know, prospective customers. Now that's fine depending on your role within the company, but if you're just a run-of-the-mill average employee, that's very broad. And, you know, raises some red flags. So it's important that those particular parameters are looked at, because going back to what I said earlier, reasonableness, the courts will assess whether or not the definition of competition, a competing business, is reasonable. You know, I was trying to do some case law research to get kind of, you know, a lay of the land about what's been recent, but I found, you know, looking at a case that I've read before about Estee Lauder, that's a global brand, right? They found that, you know, even though it was a global non-compete, it was okay because it was reasonable in light of the fact that Estee Lauder is a global brand. So again, it's going to kind of be fact specific, but if it's not a global brand, or let's just take New York State, for example, let's say I work for an employer here in Albany, but the ban is the entire state of New York. If I don't do business in the entire state of New York and I'm focused in the capital region, that kind of doesn't jive and that doesn't, seem reasonable. And so I do think that those are things that you want to just kind of keep an eye out for when you're looking at these non-compete agreements. The other thing I want to note is time limitation. So typically courts enforce restrictions of about a year. However, it depends, right? It can be up to, I saw a recent case, up to 5 years, depending upon the nature of the business and the skill of the particular employee. And again, I want to just kind of go back to what I said earlier. If we're talking about a higher level executive, somebody who's bringing a unique set of skills and knowledge to the particular role, then certainly a longer non-compete provision would be something that would be potentially reasonable or considered in that. But again, if you're just talking about your average median salaried worker, that's not going to be reasonable, right? 5 years for those folks is not going to be reasonable. And so that is something I think that you could potentially push back on if you were, an individual who's seeking to challenge the non-compete.
Sorry, I just also want to give Sarah some time to speak, but those are all really interesting points, and I'd be curious, Sarah, on what your comments or remarks are on anything Professor Hutter has said, anything Kristin has said, and that's okay, and anything in addition that you think that we should consider.
For sure, and thank you.
Oh, I'm sorry.
And don't worry at all. The wonderful thing about practicing in this area is that there's no shortage of interesting issues to cover and interesting dynamics between policy and jurisprudence that we have to tackle all the time as practitioners. So you've already heard from Professor Hutter and Professor Lobel and Kristin about the overview of the FTC rule. Non-competes generally, and individual employee considerations. And what I'm going to cover today is the intersection of the FTC rule with trade secret law. After all, even the most restrictive jurisdictions that do allow non-competes, they are allowed for the protection of trade secrets. So what can organizations do in a world where the FTC rule goes into effect and non-competes are banned? Will it cause chaos in the streets and a free-for-all in poaching talent? My perspective is not exactly. I'm going to talk about some of the implications that we know may happen if the FTC rule does go into effect for trade secret litigation. Some choice war stories that I've seen in the context of my practice. And given the electoral outcome, I'm also going to highlight some possibilities. I will not make any predictions about what the forthcoming Trump administration might or might not do. So first things first, what impact would the FTC rule have on trade secret litigation? The short story is that it would almost undoubtedly increase. And looking at California as the paradigmatic example, as you heard from Professor Lobel, we know that trade secret litigation in that jurisdiction outpaces any other jurisdiction in the country. Many practitioners believe that this is the direct result and the inevitable result of the lack of non-compete clauses as a tool in the toolbox of employers. The numbers bear this out. So if you'll bear with me on some statistics, from 2021 to 2023, California federal courts handled the most federal trade secret litigation. The Central District of California had 191 cases in that time period, which alone accounted for 5.4 of the federal trade secret docket nationwide. That was followed by this by the Southern District of New York and then the Northern District of California in third place. A couple of other interesting statistics. While 79% of federal trade secret cases were settled or resolved on procedural grounds, out of the 115 cases that went all the way to a jury verdict, including one of mine in this time period, the plaintiffs won 6 times as often as defendants, which is pretty wild to think about. This was true in the 2 trade secret cases that I've gone to trial on. Both times the plaintiffs prevailed to the tune of 8- and 9-figure jury verdicts. Unfortunately, I was only on the plaintiff side once of those 2 cases, but that's another story. So without non-compete clauses as a way of protecting trade secrets, companies would inevitably have to hang their hat on other mechanisms to protect them. So the Federal Defend Trade Secrets Act, as well as state trade secret statutes, are one of those ways that you would be able to protect your trade secrets if non-competes were in fact unavailable. However, query whether this is a good outcome for anyone except litigators like myself who handle these cases. Trade secret litigation is extremely expensive. There's almost always a rush at the beginning, at the at the preliminary injunction or temporary restraining order stage, where there's a rush to court, a flurry of activity, and often expedited discovery. Then you have almost always very intensive fact discovery. This includes the nitty-gritty of imaging the devices at work, as well as very often personal devices and reviewing all of that data. You can imagine that clients are just thrilled to give you their personal cell phone and have you inspect every nook and cranny of it to see where the trade secrets may have ended up. You can also guess that it's a very reasonable cost to do all this, very, very reasonable. Then the motion practice and discovery is extensive and almost always scorched earth. And unlike other types of commercial disputes, there's almost always, at least in my practice, expert discovery. This all funnels down to the summary judgment phase, and most defendants do take a crack at summary judgment, which in itself is hugely expensive and time consuming. And then, if summary judgment doesn't get rid of the case, everyone goes to trial. And so I've gone to trial on 2 different trade secret cases. Both of them were several weeks of teams of lawyers working around the clock, which is all to say, can we really say that all of that time and treasure spent on lawyers is a better use of resources than a reasonable non-compete clause in an agreement? I will leave that question open. So short of this very, very, very expensive, I cannot emphasize that enough, adventure into trade secret litigation, what can employers do to protect their trade secrets with or without the FTC's rule? The bottom line is that if you are an organization that has trade secrets, and most organizations believe that they do, you should have a trade secret protection program. So what I'm going to do is walk through some of the big buckets of protection that we focus on when we're advising clients on this issue, and also highlight some of the pitfalls where things have gone wrong, where we have used this to our delight and our advantage in litigation. Here, the guiding principle is that preventing the loss in the first place is always better than seeking a remedy. And you have to understand that despite the employee handbooks that have been mentioned, the employee agreements that have been mentioned, onboarding and everything else, a prevailing and dominant mindset among employees, and this is not a criticism, is that they believe that they have a right to the information, especially if they participated in creating it. So you can imagine a software coder working on a program or a salesperson developing a book of business. In my mind, it's perfectly understandable that someone who's worked really hard on that piece of product thinks it's theirs to take with them. To that end, one recent study found that 59% of employees surveyed admitted that they had taken confidential information with them when they left their job. So compound this belief with remote work, ever-evolving ways of taking the information. Think of it, all the computer technology and security features in the world. If you have a camera on your phone and you can take a picture of your screen, there you have it. So what can you do? For the most part, companies can strike a reasonable balance between having security features that work and making life not miserable for their employees so they can actually use the trade secrets to get things done. Not every trade secret is going to require Fort Knox protection like the Coca-Cola recipe or the KFC secret recipe. So the first step is to understand the landscape of the trade secrets themselves. What are they? What risks do they entail? And how did they come to be in the organization? One thing that we get asked a lot is, should we make a list of our trade secrets to inventory them? We frequently counsel our clients to not do that. The danger of having a list is that if something in the future is contested and it's not on the list, you've got a big problem. The second step is to evaluate and update all of the kinds of protections that you would have on trade secrets and other kinds of confidential and proprietary information. So I recently had a case where the plaintiff accused our client of stealing his trade secrets, breaching a non-solicit, other causes of action that were related. Important to note that here there was no operative non-compete. We were able to demonstrate, however, that the employer had the bare minimum, at least this is what we argued, for 2024 in terms of security measures. All they had was the requirement that you had to have a username and password to get into the laptop for the company. However, they allowed employees without any formal policy or registration, anything like that, to use personal devices, including computers, phones, other connected devices, which basically gave the employees free rein to save information and use information on any device for any reason. So there was no kind of need to know tiered system of access, no different levels of security. And their case quickly fell apart when they realized they would not be able to show that our client had actually done anything wrong and that they could be putting their entire portfolio of intellectual property at risk by just pursuing the case. The last thing they wanted to have was an adverse ruling by a judge saying that they had not taken adequate measures to safeguard their trade secrets and that therefore they were not trade secrets at all. So that was just one example of how you can take what a company has or has not done and turn it around to your advantage. The other step is to evaluate third-party implications. So here, think about any kind of vendor who a company might be working with, any kind of supplier, something like that. You can easily see how trade secrets start to become possibly at risk in that kind of a relationship. One case that I had that went to trial involved this exact scenario. A small agricultural tech startup company pitched a pilot project to one of the country's largest supermarket retailers to deploy our client's technology to monitor food freshness in the supply chain. And to be clear, for those of you, probably most of you who are not as intimately familiar with this issue as I am now, food freshness and its waste is a massive problem. In the United States alone, between 30 and 40% of all fresh food, all of it, is lost, just gone between the fields where it's picked and the supermarket's shelves. That amounts to roughly $160 billion a year in waste. So if you can eliminate that problem or even just mitigate it, this is something that's hugely valuable. So what happened in this case? My client entered into a pilot program. And even though there was an NDA and a joint venture agreement between the two, what ended up happening was that my client's information and trade secrets were distributed all over the corporate side of the company. And eventually it managed its way into certain channels where the company that they had partnered with misappropriated it and then tried to pass it off as their own proprietary technology. So after a 2-week jury trial in federal court, a jury returned a 9-figure verdict for my client. And that's something that's still being bitterly fought today. Back to the expensive adventure part of trade secret litigation. There's a bunch of other detailed steps that my firm regularly advises clients to take when they're developing a trade secret protection program. If you're interested in checking them out, we have a very detailed list for free on our website, so I will direct you there. But, you know, if regardless of whether the FTC rule goes into effect or not, there's plenty that companies can and should be doing to make sure that they're using best practices to protect their trade secrets. And when they don't, that's when they usually call someone like me. So very briefly, the last part I'm going to talk about is, as promised, raising some possibilities for what might happen in the Trump administration. This is really, for me, the demonstration of the adage that politics makes for strange bedfellows. You would assume that because it's a Biden proposed rule, it would be just wiped away with a Trump administration, but I'm not sure that's actually the case. So first thing to know is that there's actually bipartisan support for a non-compete ban. US Representative Matt Gaetz has supported the FTC rule and went so far as to submit an amicus brief in support of the FTC, of all things, in the leading case against the FTC, which is the Riden LLC case that you heard Professor Lobel mention. Senators Marco Rubio and Maggie Hassan introduced the Freedom to Compete Act in 2023 for the second time, which largely tracks the FTC's rule. And given the Trump campaign's major effort to rebrand itself as the party of ordinary working Americans, it wouldn't surprise me that there'd be a pivot towards support for a non-compete ban outright, even when Trump is notorious for using non-competes in his own employment agreements on his campaign staff. It's also worth noting, however, that Riden LLC, the accounting firm who's the plaintiff in the leading case against the FTC rule, is a tax advisor to Trump and a Republican mega donor. To take one example, they gave $275,000 to the inauguration committee in 2017. Just a couple fun facts. But in terms of whether or not the chair of the FTC, Lina Khan, would stay or go, she also has some very interesting supporters in Washington. You have JD Vance, her fellow Yale Law graduate, supporting her outwardly, saying that she's one of the few people in the Biden administration who's actually doing a good job. Again, you have Senators Hawley and Representative Gaetz commenting on FTC enforcement actions, praising their work on busting up monopolies and working on antitrust. And you also have, you know, renewed focus on worker mobility from different parts of the Republican Party. At the same time, however, you also have individuals like Elon Musk, who's going to be the head of the new, I think it's called the Department of Government Efficiency, who commented the other day on Lina Khan, she will be fired soon. So all to say, a lot of interesting dynamics happening on this very issue. And I don't think it's clear cut to say yes or no, not the rule is dead. Yes or no, the FTC is going to no longer pursue the cases that are currently pending in federal court. It remains to be seen. So with that, now that you all have a little bit more information on trade secret law and where things may be going, I will leave it to Professor Lobel. Thank you.
That was great. So I took from that always, it depends. Professor Heverly's favorite remark. So now we will turn to Professor Lobel. Let me bring her for our last keynote. Let me pull this here. And you have the floor, Professor.
Thank you. That was really great. It was really great to listen to everybody talk about their experience and to learn more about what's happening in New York. And to pick up on what was just presented as the potential for bipartisan moving forward with a national ban, and even more so the fact that it's complicated and that there are lots of different ways to frame what we're talking about. That's really what I want to focus my next notes on, the fact that we are in a mixed zone. So I always think about non-competes as at the intersection of employment relations, contract law, antitrust and competition law, and intellectual property law. And because it's this zone at the intersection of so many fields, it really isn't and should not be thought of as simply a question of business versus labor, employer versus worker, who individually has the right to prevent or to compete. It's not just about that. It's also about that. I'll say that, and I'll say more about how non-competes affect employees all the way up and all the way down, from the most vulnerable and low skilled. We heard about the Jimmy Johns, the Amazon warehouse workers, all the way to the top, CEOs, engineers, doctors, architects, attorneys. Interestingly enough, for those who don't know this in the room, attorneys cannot sign non-competes because that's something that the ABA has long held is against the professional rules, because the right to choose your attorney, to continue attorney-client relationships is so important that it's not right for a firm to disallow an attorney to move to a new firm and take along, or start a new firm and take clients that they have worked with. The AMA, the American Medical Association, has been struggling with that same question. And in my book, Talent Wants to Be Free, I talk about it as the tale of two professions, where the doctors have stopped short from saying that it's unethical to have non-competes, but a lot of states have gone that way of saying in healthcare, it's so important that just like attorney-client relationship, patient-doctor relationships are so important that we want to allow doctors to be able to move to another clinic and to tell their patients, come with me, start a new clinic. And it's an area where the FTC actually shows a lot of numbers, a lot of work on how banning non-competes will decrease costs in healthcare, because there'll be more competition and more clinics and just more action in trying to get patients to come elsewhere. And they have a lot of evidence-based stats on how that will save millions in healthcare costs. And I urge you to look at those numbers. So because of all that, let me go, let's see if this is flipping. And as you remember, I had some initial slides that I wanted to show you about what the FTC Act says, so you can see this quickly, and I can send these, but I'm going to move through those and go to here where I started now. It's saying we're at the intersection of contract, employment, antitrust, IP, and what do we know from the research? So this is an area that maybe 30 years ago we basically had intuitions about, but we didn't have a lot of empirical data to support this idea that when we have non-compete bans, we have more employee mobility. I think that's intuitive. Employees can move more often to new competitors, but that also fuels new entry into markets, startup culture, and competition. And the intuition started, I can tell you personally, for me, it started when I was on the move, or when I had moved from the East Coast, where I was in Boston, and then I was in Connecticut teaching, and I moved to California, and I continued to teach trade secrets and employment law and competition law. And suddenly I came across this longstanding ban in the Business Code of California. This is section 16600 of the Business Code of California. And notice that it's not in our labor code, it's in our business code, that says that it is an unfair practice or that every restraint on trade and restraint on someone pursuing their profession, every contractual restraint as such, it doesn't use the word non-compete. So that's why also in California, like the FTC Act or the FTC rule, we interpret this to include non-competes, non-solicitation agreements, NDAs, overly broad NDAs, and non-poaching agreements, so non-solicitation of clients, but also non-poaching of former coworkers, penalties on movement. So any restraint on trade is void and unenforceable and is against California public policy. So that move from the East Coast, where I saw enforcement of non-competes within the range of reasonableness, to the absolute ban of this, what I call the hardest stick, the most kind of absolute tool to prevent what we've heard of prevent leaks and prevent the loss of trade secrets and other investments, possibly of the employer. That straightforward tool of not allowing an employee at all to compete was off the table in California. And there was this intuition that that had fueled Silicon Valley and the startup culture in the tech regions of our state. What happened in the last, I would say, 15 years, more than that, but primarily the past 15, 20 years, is that suddenly not only policymakers and legal scholars were turning their attention to this distinction, but more so, we saw a lot of business school professors and economists, industrial organization people, turning their focus to that question. And if you think about it, it's actually a dream of a researcher to have this state variation. So we have a lot of variation, not only the fact that California and now just a small handful of states completely ban California, ban non-competes like California, but this idea of reasonableness is enforced differently in different states. So here's the restatement of contracts. It says that a non-compete will be unreasonable if the restraint is greater than needed to protect business, the business or goodwill of the employer, and that it also will be unreasonable if it is outweighed by the hardship it presents on it imposes on the employee, as well as if it creates this injury on the public and public interest. So if you think about it, I think about it as like these two triangles when we think about reasonableness. We have the time, subject, and space that we talked about. But we also have the employee who might experience undue hardship, but also the public interest. And that's again, the piece that I want to emphasize when we think about innovation policy and all these impacts of non-competes on competition, a new entry, and the ability to innovate. Here's the California Business Code. And so the reasonableness standard in 1952, a court said, what we really see is a sea, vast and vacillating, overlapping and bewildering. It says that you can really not understand the strange landscape because there's so much variation there. Let me skip over it back to the multiple effect. So I said we had these intuitions, and now we have much more research, and I want to talk about these multiple effects. So one of the things that happens with banning non-competes, or at least banning most non-competes. And this is why I emphasize that there's variation between the states such that we can even see some variation in these effects with what we call low enforcing states versus high enforcing states. So there's codes on, researchers have created these codifications of, well, Massachusetts is on the lower end of enforcement because the rule of thumb is that you don't enforce longer than 6 months or 1 year non-competes, and you require garden leave, and you require advance notice, and you ban all non-competes in the lower wage work or different industries. And you don't enforce a non-compete against somebody who was fired, only somebody who left with their own volition. These are just examples of the way that the codes for the research have been done, of asking a lot of questions on the range of reasonableness, the way that different courts have interpreted it. And we see that all these goodies, all these multiple effects of positive developments that happen when we don't enforce non-competes, they're also pronounced not as much as when we have an absolute ban, like with California or the FTC ban, but they also, we have benefits from lower enforcement versus higher enforcement. So what are these benefits? One is, if you think about non-competes as functioning to absolutely prevent any trade secrecy leaks, as we just heard from the previous speaker, well, trade secrets, as every intellectual property prong or type of intellectual property, we always draw lines between what is really protectable and what has to be available for us to build on the progress and the wisdom of our predecessors. So the way we innovate is to stand on the shoulders of giants. And the way that industry moves is from knowledge spillovers. And when you prevent people from moving around an industry, you will see less innovation overall. And so I just want to say on the statistic that we heard in the previous presentation on our panel, we heard the statistics that California uses more trade secrecy litigation because we don't enforce non-competes. The causality there is not clearly established because California is also a very, very high innovation region. It also is per capita the highest patenting region and highest entrepreneurial and VC investment region. So you would have to do more than just say like a sheer number. It's also the biggest economy to show the sheer number of we have, and this was like still just 100 whatever reported cases and in trade secrecy. We would really need to know the reason why we have more of that action. But it is an important message that there's still very strong trade secrecy litigation, and there are ways to protect real trade secrets without having that stick of confinement that absolutely prevents knowledge spillovers, which is a positive thing established by every economic analysis, that it's good to have general skills and just knowledge about a scientific field flowing and interchanged. It densifies networks. So that's the other piece of it, that people know each other much more and they collaborate when they are more likely to move and to job hop in high innovation regions. And so there are studies that show these densification of networks where there are much more inventor collaborations, exchanges when we don't enforce non-competes. The match quality, what is that? When one of the things that I think is important, again, to understand with this question of non-competes and why I think it can be a bipartisan consensus that we don't need them, is that everybody, it's not between workers and businesses in the sense that businesses are giving up something in an asymmetrical way. Rather, all businesses are agreeing that they won't use that stick, that stronger stick. And sometimes they'll be in the losing side, but sometimes they'll be on the winning side. So this issue, unlike, let's say, wage and hour litigation or employment discrimination litigation, when we have non-compete litigation and trade secrecy litigation, it's really, we have two businesses, one which has lost an employee, a valuable employee, and the other that's gaining it. And here in California, I speak a lot to the biotech community in particular. They really want to have that ability to match positions, match new ventures, match new R&D initiatives quickly with the best employee that's out there. And again, they understand that there's going to be a repeat game that's going to compete over that employee, but they want to also be able to be on the winning side. That also creates agglomeration economies, what we call these like dense places where you can recruit talent more flexibly because they're already there. So that's the big puzzle of like, why do people come to set up shop in Silicon Valley or in Biotech Beach when we don't enforce non-compete? Well, they benefit from all these goodies of having high human capital regions where they can recruit flexibly. It also increases the motivation of the employees themselves. And that's a lot of important research that I've done with behavioral economists, with experimental economists from UCSD and other places, where we show that when people see their career trajectory as their own, they improve their performance. They are willing to invest more in their humans capital, in inventing and being a star employee, because there's going to be an active market over their minds. So that's a win-win again. The other thing that we didn't talk about of like what would happen if we don't have or if we do have a ban on non-competes nationally. Well, what we saw in California is that you don't only use trade secrecy protection, but actually use carrots, positive incentives to keep employees with you when they're free to leave. So California has a much higher rate of using performance-based incentives, including stock options, vesting benefits, such that, again, that's kind of a motivating fuel of, we'll be the best company possible because people are free to leave. If I'm Google and somebody can go the next day to Microsoft or Facebook, I need to keep being a really good employer that gives incentives to employees to want to be here. I talked about the specific fuel of entrepreneurship, which is very important to a healthy economy, that there's new entry, and the FTC and many other reports show that the labor markets, our labor markets, are more concentrated than our product markets. So if you think about it, and this goes also to what I have here, a line that says monopsonies and wages. If you think about non-competes as part of competition policy, I think it's helpful to think about it as an analogous to price fixing. Really, non-competes are wage fixing. They're agreements that there won't be a call from Apple to an employee of eBay saying, we'll pay you more here. Everybody's not hiring each other's employees because they can't, because there's all these horizontal collusions, and that fixes wages. It suppresses wages, and it prevents the raising of wages. And that brings me to the final point. I have also here brain gain. I just wanted to mention that one, that we also in California, I know anecdotally that we, and also in the research, that we gain the best talents because they come here because there's going to be an active recruitment and competition over their talent. So we get the best inventors from Michigan and New York and Connecticut to come here. So that's when there's state variation. But then the final point, and then I'll stop, is the point about equality. That also, just in the past few years, we have strong evidence that when there's less mobility, when there's less job hopping between companies, there's a disproportionate harm to women and minorities who are traditionally and still today underpaid. Why? Because several things. One, when there is a pay gap, when there's a gender and racial pay gap, how are you going to correct it? The way that that closes, the way that we will be on track to eliminate that pay gap is by having these external offers that really show employees their true value. And that doesn't happen when jobs are not offered and there's kind of stagnation and fear of leaving. And then there's other effects that are related or other reasons, which are that women, for example, have disproportionate kind of non-tangible preferences to be at a place that is free of hostile work environment, that hasn't been sued for sexual harassment, that is known to be more diverse. And so if women already have more narrow preferences and specific preferences on the kinds of places that they are willing to work at, and sometimes more geographic constraints on average, then non-competes will have a disproportionate harm on them. So again, all of these point, in my opinion, to, and I'll stop the share, to hoping that the FTC ban will be approved, will go through eventually. And if not, I agree with the speakers that there are other ways. I think we should be diligent in continuing the law that we do have and interpreting it in ways that really take into account not only the harms to employees with non-competes, but to the market at large. Thanks.
Thank you, Professor Lobel. Now, there was a lot of really interesting comments made from all of our panelists. I'm sure we all have a lot of questions. So can I get one or two questions from the audience, or if there's anyone on Zoom that has a specific question as well, just message and I will read that out for you. We have a question in the back. Where's the mic? Oh, perfect.
Hi, Morgan. This question is for Ms. Foust. I was asking because earlier you mentioned that in a non-compete agreement, if the definitions of what a competitor is and if the various definitions within the non-compete are too broad, then that can go against the reasonableness of the agreement. What about when the agreement is silent on definitions? It just blankly states, well, you cannot go to a competitor, period. No further explanation. You cannot work in a certain area in this field, and it doesn't necessarily define what kind of work that entails. How does that play into a reasonableness analysis, if at all?
That's a great question. Well, that's a very poorly drafted agreement. That would at least be what my perspective is. But it would be the great answer. It depends. It would really kind of, I think, then turn to, well, you know, if you're trying to litigate it, what is the actual business? What do they do? What type of work do they perform? What services do they perform? It would really kind of be very fact intensive. Whereas if you had a defined term in an agreement that specifically delineates what the business is, it would be easier. In that context, it's gonna be more challenging, I would say, for the employer to demonstrate what the competing, what the competing business is, or it would be more subject to interpretation. So in that regard, I think it would just depend and be very fact intensive, but I do think that helps the employee because it's not defined, so you can kind of make the argument that maybe it is more to your benefit. Flip side, the employer could then, make an argument that it's more to their benefit, but that's a tough definitive answer, but a really great question.
If I could just add my 2 cents from a litigation perspective, we've successfully made the argument on multiple occasions for our clients that a lack of a defined term like that for a critical term in an agreement like competitor, or a lack of definition for the geographical scope, things of that nature, or competing business, have rendered that restriction overly broad and therefore unenforceable. And that's true in the jurisdictions where I practice, Massachusetts and in New York, but also in other places around the country. So if I were representing the employee and I was reviewing that agreement and I saw a lack of a defined term like that, I would definitely make a note and then think to myself, bingo.
The lack of a fact could be a fact. And there was another question down here.
Thank you. Okay, there we go. All right, my question is for anybody who wants to answer it. I don't have anyone specifically. But my question was about the issue of when an employer has an employee sign a non-compete agreement that may be under current law now legally dubious, maybe it's on the edge, or maybe it is clearly not reasonable and it is unenforceable, but the employee themselves does not realize that the agreement is unenforceable. So it's still operating properly as a stick to prevent them from going out and finding other employment. Do we think that the bans that simply blanketly void those contracts, do we think that those are still going to adequately address the fact that employees themselves may not realize that these contracts are void, and employers still are able to use that leverage over them, even if the contract doesn't actually mean anything?
That's a great question, and it's for that precise reason that the FTC has included in its rule that you have to notify your workers that they may have had a non-compete in the past and that it's now invalid and no longer applies to them. So if you look at the rule, there's actually a little proposed notice that employers can use verbatim that has to be delivered to them in some way. I think the rule even specifies that you can text it to them if you can't find them through another means. But that sort of a notice provision is also something we've seen in California, where there was a more recent update to their non-compete law that required them to notify employees if they had a non-compete or a different type of restrictive covenant that existed in the past, that it was now definitively dead, void, valid. And I think if there is no FTC rule that goes into effect, that will probably continue to be a trend among state legislatures, because to your point, they're very aware that it's used as a deterrent effect. And if you don't know what your rights are, then you're not going to know that it doesn't apply to you.
Is there anyone else that has any questions or on Zoom? Or any other additional comments from any of the panelists that you feel like we need to re-emphasize or revisit?
Just one very quick plug for my favorite area of law, choice of law and conflicts of law. If this is an area that speaks to you, this area of practice is the most fun area of practice imaginable. Right now, a trend in state legislatures is trying to enforce their individual laws to the benefit of their state citizens, regardless of where else they might be working. So we've seen that in California, Minnesota is another example. Even Massachusetts has a related provision. And so if there's no national rule, the classic issues of choice of law come into effect. So to take California, for example, now the update to their statute says that any employment agreement containing an invalid non-compete, regardless of where it was signed, is invalid in the state of California. So what happens, for example, if you're someone who joins a company in Massachusetts, signs a non-compete that's valid under Massachusetts law, and then after you resign, you move to California and try to work for a competitor, which would otherwise be impermissible under your non-compete. Do you get the benefit of California law as a new California citizen? Or do you have to abide by the Massachusetts non-compete? In a recent case in Massachusetts that my firm was involved in, the Massachusetts court said, no, not so fast. So sorry, you don't get California. You are stuck with Massachusetts. So just a plug, if that is of interest to any students in the audience, it's a really interesting area of the law, implicates questions of federalism, comedy, all of those fun things. So I definitely recommend it.
I would agree with Sarah's comment. The conflict issues are incredible. It's something you really have to take into account. California statute that Sarah just mentioned, other states, our Court of Appeals has refused to enforce a Florida law because it's against New York public policy. What's against public policy? You just really have some real serious issues. And I could add from my perspective, I teach conflicts and I'm a member of the advisory group of the restatement, American Law Institute, that's doing a third restatement. And this is one of the thorny issues that we're trying to put a handle on. And I'm not sure it's going to be done common law. I think it's got to be done completely by statute. I don't think you can let each state act where it wants. And I'm not necessarily always a Fed, but I think this is one area where I would see the FTC to step in and have some sort of, a Congress to have some national conflict law on this issue, but only on this issue. I don't trust Congress.
All right, well, I just want to say thank you, Professor Hutter, Kristin, and Sarah, and Professor Lobel, who is able to join us. Thank you, Savannah and Madeline, and Professor Heverly for letting me come back. And we invite all of you to join us in the East Foyer by the main lobby for some food and some drinks and some very interesting discussion. And thank you all for coming.
Just add one thing. I don't know if anybody is familiar with Sarah's firm has this terrific blog. I have it bookmarked. I'm always getting updates. If you really want to keep current, and you have to, Biden, Beck, Reed, their blog is one of the best I've ever seen. I've been a subscriber from day one when I heard about it. But I would really highly recommend that you keep in touch with this area by the Biden Beck blog.
Shameless plug. Great. Thank you all.
Start spreading.